Hey besties, welcome back to my channel. So, the New York Times is playing an interesting game in the media right now. And honestly, it's wild to say that. Because growing up, I always thought of the New York Times as the gold standard of journalism. If something made it into the Times, it had to be true, right? But over the years, we've learned that no outlet is perfect. Mistakes happen. Some stories get things wrong. And sometimes, outlets even publish information that turns out to be flat out false. Still, there's a very high legal bar you have to clear in order to successfully sue a journalist or a major media outlet. And honestly, that's a good thing. Because the worst thing that could happen to society is the suppression of free speech and a chilling effect on the free press. Now let's talk about the case at hand. Justin Baldoni versus the New York Times. Baldoni filed suit after the Times reported on a CRD complaint that Blake Lively had filed in California. Under New York's fair reporting privilege, media outlets are allowed to report on documents filed with government agencies, even if those documents are marked confidential or haven't been publicly released yet. That's why the Times was legally protected when they published information about this CRD complaint, even though Blake later tried to claim it should have been covered by a protective order. A few weeks ago, the Times filed a motion asking the federal court for a final judgment. Why? Because if they can get a final judgment, Baldoni could then appeal. If the appeal moves forward, discovery would begin. If the appeal fails, the case would be over. Essentially, the Times doesn't want to stay stuck in this litigation any longer. Once they filed that request, Wayfair had 3 weeks to respond. Their response is due imminently, either tomorrow or Monday. Until the judge actually issues a final judgment, though, several things are on hold. The Times can't ask for attorney's fees. They're technically still part of the case, and no one can appeal yet. But here's the twist. That hasn't stopped the Times from making another move. Instead of waiting around, they've been spotted shopping around what looks like a lawsuit in state court, even though the document itself hasn't officially been accepted by the clerk. This document is circulating in the media, but it has a huge red flag across the top. This document has not been reviewed by the court. Caution. Basically, it looks like a lawsuit, but the index number is unassigned, meaning it's not valid until the clerk accepts it. The clerk could still reject it outright. What the Times is attempting to do here is really interesting. They're not just asking for attorney's fees in the federal case anymore. They're going to state court, suing under New York Civil Rights Law Section 70A, which is part of the state's anti-SLAPP statute. Under this law, if a defendant is sued over public participation, like news reporting on an issue of public interest, and the case is found to lack any substantial basis, the defendant is entitled to recover damages, including attorney's fees and costs. Essentially, it punishes people for filing frivolous lawsuits meant to silence free speech. The Times is arguing that Baldoni's lawsuit was exactly that, baseless, meritless, and an attempt to intimidate them for publishing something unfavorable. They point out that the federal court had already dismissed the claims against them, noting that even where the reporting went beyond the CRD complaint, there was no evidence of actual malice. In fact, the court specifically noted that the CRD documents and related reporting contained enough material to reasonably suggest that Wayfair and its affiliates were engaged in a smear campaign against Blake Lively. And while there were some text messages floating around that seemed damaging, they weren't enough to prove the Times acted with reckless disregard for the truth. The article importantly also included Blake's denials in context that undercut any claim of bias or malice. The federal court dismissed multiple claims outright, including defamation, false light, promissory fraud, and breach of implied contract. The judge flatly stated that no contract existed. The only so-called promise was an email offering Wayfair until noon to comment, which is a standard journalistic practice. Now here's where it gets even more costly. The Times claims they've already spent at least $150,000 in legal fees and costs defending themselves against Baldoni's lawsuit. And under New York's anti-SLAPP statute, they want every penny of that back, plus potentially additional damages if the court agrees. So what we're seeing is a multi-layered legal chess match. The Times wants the federal judge to issue a final judgment so they can either move forward with an appeal or close the book on this case. At the same time, they're trying to leverage state court laws to force Baldoni, Wayfair, or anyone else involved to pay up for dragging them into what they say was a baseless, retaliatory lawsuit. The bigger picture here? This isn't just about Blake Lively, Baldoni, or even Wayfair. It's about how far the media can go in reporting on sensitive cases, and how powerful anti-SLAPP laws are becoming in protecting journalism against lawsuits that aim to silence reporting. And trust me, this fight is far from over. So here's what the New York Times is really saying. Since all they did was report on matters of public interest, specifically, this legal filing, and because their article actually gave Justin Baldoni a favorable arc while also including his responses, there was no actual malice involved. That's the standard that matters most in defamation law. And because of that, their reporting falls squarely under New York's anti-SLAPP law, which entitles them to recover attorney's fees. Now, don't get me wrong. I am absolutely in favor of freedom of the press and freedom of speech. I've said that from day one. But here's the thing. I never really understood the strategy of going after the New York Times in the first place. It's almost impossible to beat them in court, and frankly, the lawsuit always felt more like a PR maneuver than a legal strategy. Sure, some people genuinely believe there was a case to be made, and to be fair, there are valid questions about whether the Times accurately portrayed the CRD complaint versus portraying it as a full-blown lawsuit. Those kinds of details could potentially be raised on appeal, but this new move by the Times feels more like gamesmanship. First, they're pushing this out to the media as though it's a brand new lawsuit, when in reality, the document hasn't even been accepted by the court. Second, they filed it in New York State Court, which is suspicious because it looks a lot like forum shopping. Why? Because in federal court, specifically the Southern District of New York, judges often refuse to apply New York's anti-SLAPP statute. In fact, the Second Circuit has repeatedly held that certain parts of the statute simply don't apply in federal cases. The proper way for the Times to handle this would have been to file a motion for attorney's fees in federal court after the judge issues a final judgment. That hasn't happened yet. Filing in state court is risky because Justin Baldoni and Wayfair could easily file a notice of removal and drag the case back into federal court, right back before Judge Lyman, who already dismissed the claims. Since this fee dispute is directly tied to that federal case, it logically belongs in federal court under 28 U.S.C. paragraph 1441 and paragraph 1367. If the case gets removed, the federal judge could treat it as a post-judgment fee dispute and simply say, "This belongs here, not in state court." Judge Lyman has already stated that Reynolds, Lively, and Sloan could seek attorney's fees by filing a separate motion. So this isn't new territory. Here's another wrinkle. Under the rules, motions for attorney's fees are usually supposed to be filed within 2 weeks of dismissal. The Times didn't do that. Instead, they went the state court route, which really makes it look like they knew they'd have a tough time winning fees in federal court. And if it's removed back to federal court, all they've really done is waste resources and drive up their own legal costs. This is also why it looks like forum shopping. If you know one court is less likely to give you what you want, you try another court that might be more favorable. But that tactic doesn't always work, especially when federal rules are clear about jurisdiction. To make things even messier, New York's anti-SLAPP law was amended in 2020, and courts are still split on how it applies. Some federal judges say fee shifting is allowed, and they'll award attorney's fees in cases like this. Others say the statute conflicts with the federal rules of civil procedure and refuse to apply it. In short, it's a gamble. So the Times is essentially taking a calculated risk. They're betting they can either keep the case in state court or force a ruling that will let them recover at least some of the $150,000 they claim they've already spent in legal fees. But nothing about this is guaranteed. And at the end of the day, Wayfair and Baldoni are absolutely going to argue that the Times has no right to fees under federal law. This entire move just reinforces how much of a legal chess game this has become, with the Times maneuvering for advantage and Baldoni's team preparing to strike back. Today, we need to talk about what's happening in this tangled legal mess, because honestly, the way this case is unraveling feels like something out of a courtroom thriller, and yet it's very real. We're watching powerful people, Hollywood names, major media outlets, and high-profile lawyers clash in a battle that touches on freedom of speech, freedom of the press, and the limits of what can and can't be said about public figures. And right in the center of all of this chaos is Blake Lively, Justin Baldoni, Wayfair, and the New York Times. If you've been following along, you know this has been a whirlwind of filings, counterfilings, accusations, denials, and judges who seem to want as little to do with this circus as possible. But now things have taken a new turn, and honestly, it might just blow up in the faces of some of the biggest players in the story. Let's lay out exactly what's happening here, because it's complicated but fascinating. The New York Times, once thought of as the pinnacle of journalism, the paper of record, the publication that defined what news even was, is now in a position where it's not just defending its reporting, but also actively going after attorney's fees under New York's anti-SLAPP statute. That's a huge deal. For context, SLAP stands for Strategic Lawsuit Against Public Participation. These are lawsuits filed not necessarily to win, but to intimidate or silence critics. To prevent this kind of abuse, many states, including New York, have laws that allow defendants in SLAP suits, usually journalists, media outlets, or people speaking on matters of public interest, to recover their legal costs and attorney's fees if they can prove the case against them was baseless. And trust me, the New York Times has spent a lot defending itself in this case, with legal bills topping $150,000 and counting. But here's where it gets interesting. The judge in the federal case, Judge Lyman, already made it pretty clear in previous rulings that he doesn't like to award attorney's fees unless something is egregious. He doesn't like to make those calls unless he absolutely has to. In past cases, he has chosen to sidestep the anti-SLAP issue by dismissing lawsuits on other grounds, like fair reporting privilege or failure to plead actual malice, without ever saying the case itself was meritless. That's a key distinction. Because for the New York Times to win attorney's fees under anti-SLAP, they need to show that Wayfair and its affiliates pursued their case against the Times without any substantial basis in fact or law. And the judge hasn't said that. In fact, he's avoided saying that. So what did the Times do? Instead of waiting for a final judgment in federal court and then filing a motion for attorney's fees there, they went to state court in New York and filed a document that looks like a lawsuit but hasn't even been accepted by the clerk. The document has a big caution label on it saying it may not have been accepted for filing. The index number is unassigned, and yet somehow this document has already been shopped around to the media. And you know what that means. It looks a lot like the Times is playing a PR game here. They're signaling to the public and to their critics that not only did they win, but they're coming after the other side for daring to drag them into this in the first place. The problem is, this move might actually backfire. Because technically, this case started in federal court, and any related claims, like attorney's fees, should also be handled there. There's a legal mechanism called removal, under 28 U.S.C. 1441, which allows a defendant to take a case filed in state court and bring it to federal court if it could have been brought there originally. And under 28 U.S.C. 1367, federal courts have supplemental jurisdiction over claims related to actions already decided in federal court. Translation? Justin Baldoni and Wayfair can file a notice of removal and say, nope, this belongs with Judge Lyman, not in state court. And if that happens, it'll end up right back in front of the same judge who already avoided ruling on attorney's fees and who doesn't seem eager to award them. And let's not forget, this isn't the first time this issue has come up in this very case. When Ryan Reynolds and Blake Lively's publicist Leslie Sloan asked for attorney's fees under anti-SLAP, Judge Lyman denied their motion. He didn't say their request was unreasonable, but he also didn't say the original claims were baseless. He just said no. He even left the door open for renewal if further information came out proving the lawsuit was meritless. But as of now, he hasn't made that finding, and without it, there's no solid ground for the Times to stand on. What the Times is doing looks a lot like forum shopping, basically trying to find a court where they think they'll get a better outcome. Federal courts in the Southern District of New York have been inconsistent on anti-SLAP. Some judges say the provisions don't apply in federal court because they conflict with federal rules of civil procedure. Others say the fee-shifting part does apply and have awarded fees. It's a gamble. And it looks like the Times doesn't want to roll the dice with Judge Lyman, who's shown he doesn't hand out attorney's fees lightly. So they went to state court instead. But the thing is, that's risky. Because if the case is removed back to federal court, and it almost certainly will be, it could end up wasting even more time and money. It's like they're creating extra litigation just for the sake of making a statement. And honestly, that statement might not even hold up. Now, let's step back and look at the bigger picture here. The whole reason this started is because Blake Lively filed a complaint with California's Civil Rights Department, and the New York Times reported on it. That's it. They reported on a government document. Under fair reporting privilege, that's allowed. Even if the document is confidential, even if it's filed under a protective order, once it's filed with a government agency, it's fair game for journalists to cover. The only way you can sue for defamation over that is if you can prove actual malice, that the reporter knew it was false or acted with reckless disregard for the truth. And the court said Wayfair didn't prove that. The Times even included Baldoni's denials in the article, giving him a chance to respond, which cuts against any inference of malice. So why sue the New York Times at all? Many observers, myself included, think it was more of a PR move than a legal one. It made headlines, It looked like Wayfair and Baldoni were fighting back against negative press, and maybe it bought them some time. But legally, it was always going to be an uphill battle. And now, instead of walking away after a dismissal, the Times is pressing for attorney's fees, which drags the whole thing back into the spotlight. And remember, Judge Lyman's own track record shows he's not a fan of granting these motions. In a case called Griffles S.A. ver U, he denied a motion for anti-SLAPP fees, saying that because the plaintiffs had at least some basis for their claims, fees weren't warranted. He specifically noted that just because a case is dismissed doesn't mean it was baseless. That's the exact same issue here. Dismissing the lawsuit against the Times doesn't automatically mean it had no merit. It just means it didn't meet the very high bar of defamation law. So when the Times tells a state court that Judge Lyman ruled the case was meritless, that's not really accurate. He didn't say that. He avoided saying that. And he might avoid saying it again if the case comes back to him, which it probably will. And if it does, the Times might find themselves not only losing their bid for attorney's fees, but also looking like they tried to play the system. And here's another wrinkle. If you want attorney's fees after a dismissal, you usually have to file for them within 2 weeks. The Times didn't do that. They're going this roundabout way instead, which again raises the question, why? Why not just follow the normal process? And the only answer I can come up with is that they know their chances are better in state court, or at least they think so. But if it gets removed, all of this will have been for nothing. At the end of the day, this feels like legal gamesmanship. The Times is trying to send a message. Don't mess with us. Don't sue us unless you're ready to pay the price. But in doing so, they may have overplayed their hand. Because if Judge Lyman gets this back, and if he sticks to his usual cautious approach, the Times may walk away empty-handed. And all the while, Blake Lively and Justin Baldoni and Wayfair are still embroiled in their own legal battles, with appeals possibly on the horizon. It's messy. It's dramatic. And it's far from over. But one thing is clear, the strategy the Times is using here is risky. They could win big, setting an example that you can't frivolously sue the press. Or they could lose and end up looking like they wasted resources chasing fees they were never going to get. Either way, it's another chapter in a saga that keeps getting wilder by the day. So what do you think? Was it smart for the New York Times to take this fight to state court? Do you think they'll actually win attorney's fees? Or do you think Judge Lyman will shut it down like he has before? And what about Blake Lively and Wayfair? Was suing the Times a mistake from the start? Drop your thoughts in the comments below. Give this video a thumbs up if you're following this case as closely as I am. Make sure you're subscribed and hit the bell so you never miss an update. Because trust me, there are going to be more twists coming and you'll want to be here when they drop. Thanks so much for watching, besties. Until next time.